think we're good to go. So thank you all for being here today, and good afternoon. I'm Jeremy Berke. I'm the co-founder and editor-in-chief of Cultivated Media, and I'll be playing host and moderator today. So welcome, everyone. On behalf of our Cultivated Media team, I'm happy to have partnered with our friends at the Park Strategies and the Wagner firm to present today's webinar, Transferring Ownership of Cannabis Businesses in New York. We are happy to partner with them, not only because they're great people, but also because New York is a dynamic, new, and rapidly changing market, and it's getting more and more exciting every single day. We love to host experts at Cultivated. We love to share insights, so that's why we're here. But first, I want to make sure you know who we are. As I mentioned, I'm Jeremy. I'm the co-founder and editor-in-chief of Cultivated Media. Since we launched last November, our goal has been to be cannabis industry first, providing you with the most important, insightful, useful, and timely information. We do that through our daily newsletter, Cultivated Daily, and we do that through our daily live stream, Cultivated Live. And we also do it through programs and events like this. So while you're here today, I'd love it if you headed over to cultivated.news, that's cultivated.news, and subscribe to our newsletter, but also follow us on LinkedIn. And if you want to look at some of the most compelling industry coverage on the internet, head to our YouTube page. My colleague Jay in the backstage will put in the links as we go. And you should know that this program is being recorded. You'll all be getting a link to the complete show once it's over tomorrow. And with that, that's enough for me. So I'd like to welcome our presenters. From Park Strategies, we have Joe Rossi, Managing Director, Thomas Buchan, the Vice President of Park Strategies. And as well, we'll bring up Patricia Heer, a special counsel at the Wagoner firm and the former first Deputy General Counsel of the Office of Cannabis Management, and Mark Wagner, principal at the Wagner firm. And just a quick programming note, we won't be taking questions during this webinar, so we can keep the entire program within 30 minutes, a reasonable time frame. We do encourage you to reach out directly to us or the speakers, as they have loads and loads of answers to, I'm sure, the questions that will generate. We will put how to get in touch with them as we go. So with that, Joe, Tom, Patricia, and Mark, over to you.
Thank you, Jay. Thank you, Jeremy, for hosting us. And thank you for all the great work you're doing in this space across North America, but especially here in New York. Park Strategies is a top 10 lobby firm here in the state of New York. Been around over 20 years, founded by former United States Senator Alphonse D'Amato. Our cannabis practice group was built out of our work with on the hemp extract law, the first in the nation hemp extract law in 2019. And we've been very active in this space, and I couldn't do it without my colleague and friend, Tom Buchan, Esquire. Tom?
Yeah, it's been working with Joe in this space since the rollout of the MRTA started. We represent a number of clients in this space, both on the primarily in the beginning on the lobbying side, now also on the consulting side as well. Work with a number of cannabis clients, and pleasure to be here with everyone and working with Mark and Patricia as well.
Yeah. Thank you, guys. At the Wagner firm, it's myself, Mark Wagner. We had the corporate practice group here, and Patricia Heer, who has come on as a special counsel to assist with our corporate practice. With regards to cannabis, we help potential business owners, entrepreneurs with licensing, compliance issues, and any general business issues that any other business would have, whether it's employment, land use issues, contracts, so on and so forth. And I'll let Patricia come on as well.
Save the best for last.
Yes.
Thanks, everyone. Thanks for joining us, everyone, today. As you all know, I was at Office of Cannabis Management, first Deputy General Counsel, and at times interim acting General Counsel. I made this to the Wagner firm recently, and in addition to the services that Mark highlighted that the firm provides, we also provide litigation services, sophisticated business disputes. And we're seeing a lot of that now, right, in the cannabis market as it continues to mature. We've seen that in other states, that legalized before us, and now the New York market is starting to get there. So we also provide those types of services, whether it's at the point of where you're already going to court or pre-litigation attempting to work out a resolution. And with that plug, let's get started, huh?
So our presentation, just as an overview, Joe and I are going to give a general state of the cannabis market, how we got to this point and what we're seeing going on in the market through our contacts with our clients and industry. And then we'll turn it over to Patricia to discuss the legal framework on changing ownership. And Mark will wrap up the presentation with considerations on future ownership changes. So I want to start the presentation just by giving a timeline of how we got to the point where we are now. Obviously, in March of 2021, the Marijuana Regulation Taxation Act passed. Joe, obviously being a leader in those advocacy efforts there on the front end, and that's when I came in and to help work on our client base in the area. Beginning more than a year later, with the issuance of the first card licenses start to roll out, get the first stores open, people begin to get provisional licenses, which give you the 12-month time frame originally to get those final licenses up and rolling. That timeline's now extended indefinitely. Many of those folks still had provisional licenses, but not necessarily having the resources to get those stores up and running, kind of giving context to why we're talking about ownership changes and licenses and how to get these stores up and running. A lot of folks on that first licensure period get those provisional licenses, but haven't been able to get to the point of fully rolling out those stores. Get into September of 23, we get the adult use regulations adopted, which led to the November 2023 queue for those individuals that applied for licenses with site control, originally seeking to have full licensure. We got to the point, again, through a lot of advocacy work that we did on the ground, a lot of noise made by Joe Rossi there on the floor to say all of these folks that applied in this November 2023 window, all 2,232 of them, if they're ready to open up a store, they should get their licenses and open. We provided that all of any deficiencies are corrected within the allotted time frame. All of those folks will either get a provisional or a full license and be able to proceed with their business opportunities. Again, a lot of those folks at this point, now we're over a year out, a lot of these folks have gone out and either gotten a lease or bought a building and started to work on those buildings and need to plan to move forward to get their licenses. At this point, we're roughly 2/3 into the 1,500s on the review of the folks in that queue, still about 700 left to go, with anticipated that queue will be finalized and review in the beginning of 2025. But that's only 2,232 of those applicants. We still have another over 5,500 applicants that applied in the December queue for provisional license, all of those folks applying without site control. Still undetermined when review of that application period will start, how many of those folks will end up being granted licenses, if any at all, at what point we're going to be doing that. But a whole bunch of folks wanted to enter the market after that point and may have capital to do so and may be interested in this kind of format. Next slide. Originally, when this was rolled out, we were anticipating between 500 and 1,000 retail dispensary licenses, 220 micro business licenses, along with the number of different licenses for cultivation and processing licenses. That is part of this whole market on a regularly changing basis. Those caps now lifted. Unclear how many total licenses will be awarded and what those licenses will look like, whether we're dealing with, mostly provisional licenses at this point, and then how many full licenses will get out there. But we're still at a point where we need more stores open and we need more folks with licensure. Next slide. In dealing with our clients, we're hearing a lot of different concerns from people that we talk to on a regular basis. In the beginning, Joe and I were talking to people seeking licensure on an almost daily basis. How are they going to get in? How are they going to apply? A lot of people spent a lot of money in those early months right after the passage of the MRTA in March and April of 2021. Joe and I were speaking with businesses almost constantly. How do we get in? What do we need to do? Do we need to buy a facility? How do we get in? And I think at that point, the regulations not the regulations, but the statutes and the guidance coming out of the Office of Cannabis Management were advising people to do so. If you get in early, you get a building early, it's going to be easier to get a license. A lot of people got in and burned themselves out either with their time or their money trying to get their businesses up on the road. And a lot of those people were either left their ambitions for the market or now are looking for other folks to get involved with to try to get their business opportunities up off the ground. You have other people who didn't necessarily get a building, but now have provisional licenses at this point and don't have the capital to get started or no longer want to move forward in the cannabis business. And they have an asset in a provisional license that they want to transfer to try to get some of their investment back and capitalize on that type of opportunity. Another big problem, I think, here in the attrition of licenses, meaning that the people that got provisional licenses will never get up off the ground, which may give it an inflated number of folks that got licenses altogether, because you get the fear of the 12-month period to bring your provisional license to market. And a lot of folks won't have the resources to get that off the ground. And the other issue that we've heard regularly over throughout the time, and Patricia, not to your fault, but we've had never changing regulatory landscape, different types of documents coming out, shifting timelines when we're going to see full licenses, where people got placed in the queue, which was originally, I think, thought to be a first come first serve basis, then went to a lottery system, and some people applying in that queue several times, with the same name for licenses, even though one application could be granted for each person, and on the retail side of things, and a lot of folks frustrated in that regard. So I'm going to turn it over to Joe here before Patricia does part two of the conversation of what we're seeing now with transfers.
Yeah, and I want to get to the Patricia part of it as well. So, just how is the market handling this issues? I like to be frank. At the beginning of this year, we saw a cottage industry forming, which is teaming people with licenses and no money with people with money and no licenses. For example, there's a website, Can Delta organization out there, that just says flat out licenses for sale, and you can't sell a license. So there's that going on in the market. That's how the market's handling the issues. And then there's our friend and our former client, Mike Flynn of Flintstone, the largest dispensary this side of the Mississippi, who's just did an article yesterday announcing what we've all known, which is he's teamed up with about 30 different card licensees, retail licensees, put it that way, to help them build out their dreams because they have license but no money. So that's the facts. I'm happy to turn it over.
Thanks, Tom. That was a lot of events and a lot of circumstances to try to wrap up in a few minutes, and I won't hold it much to your comment. So let's say, right, we heard Joe just talk about some of the arrangements folks are thinking about given the circumstances that we're in now, right? And so let's say you're thinking about pursuing one of these arrangements, whether you're a current licensee or you're looking to become involved in one, or, right, you're a professional. I see a lot of professionals on the webinar, right? You're a professional advising one of these. From the regulatory standpoint, right, what do we need to be thinking about when we're thinking about one of these arrangements, right? We know that you all know that licensees are overseen by the Office of Cannabis Management and the Cannabis Control Board. And so there's generally three main things to keep in mind. The statute, the cannabis law, you all know it, the regulations of the Cannabis Control Board, and then the guidance that's put out by the Office of Cannabis Management. And as Joe mentioned, right, you can't just go off and sell a license, right? That's the basics. You can't buy and sell a license. But according to the statute, you can amend the ownership, right? Which is the interest or the share that one owns in the entity that holds the license, or you can amend the organizational structure. And that's the people that are involved, right, in the license, people that are making certain types of decisions, the people that have control. And if you make one of these types of changes, then you need approval from the board. Next slide. If you don't get that approval, your license may be revoked, or there may be some sort of other action taken, like a suspension. But the cannabis law talks about substantial corporate change, right? That can be, and what is that? Substantial corporate change, it depends on how you're organized. So you could either be, you all know this, a corporation, an LLC, or a limited partnership. And so for a corporation, next slide, substantial corporate change would be a change of 51 or more of the officers or directors, or of the ownership, right? So for a corporation would be the shares. Next slide. For a limited liability company, it would be 51% of the managing members or of the interest. Next slide. And for a partnership, it would be 51 or more of the managing partners or the interest. Next slide. And so that's with respect to substantial corporate changes. For other changes, the board can issue regulations and delegate to the office the decision-making and what would be required for those types of changes. Next slide. And the board did that, right? There's the main governing rule for this is Rule 12018, which provides that you have an ongoing, that licensees have an ongoing duty to advise the office about changes to their license. So they have to keep the office up to date. Next slide. And when you're making changes, the rules basically separate the changes into three different types of changes, right? Three different categories. Think of them as the first requiring notice to the office, the second requiring approval from the office, and the third requiring approval from the board. When it comes to the types of changes that just need notice to the office, there's the 10-day notice and then a 3-day notice. The 10 days, when you're changing a shareholder and they're getting more than 10% of the aggregate ownership, that you just need a notice, or you're decreasing someone's interest to be below 10%, or you're taking a TPI off of the license, or you're having someone come in and lend capital that would be more than 10% of the licensee. Then if you have a goods and services agreement, that would be considered a non-exempt agreement, and it would not be on a flat fee basis. You would also just provide notice to the office, or in the event a TPI dies and you're removing them from operations, that's just a 10-day notice. With respect to a 3-day notice, when you know that there's a transaction that's being proposed that would essentially be the control of at least 50% of the voting shares, once you become aware of that proposal, you'd be giving the office a 3 days heads up. Next slide. The second type of change is the type that requires office approval, not just the notice. And that's when you're adding a new true party of interest that needs to be disclosed. Or you're changing the background, or you're changing the individual who would need to go through a background check, essentially. So you have a true party of interest who owned less than 10%. Now they're going to own more than that. And we know that once they hold above a certain amount, they need to do the true party of interest disclosure form. Next slide. And the third type of change of amendment to a license is the type that requires board approval. This is consistent with the law that we just looked at, the statutory provision, and in the statute refers to a substantial corporate change. In the regulation refers to a composition of a license. And we'll talk about in a minute when we look at the guidance what composition of a licensee means. But if you're changing the composition of the ownership or of the structure of control, then you need board approval for that. Next slide. And so if you don't require, and so if you don't obtain approval or don't provide notice, right, provide that, again, your license may be revoked, there may be a suspension or cancellation. But we know that the, next slide, that the office came out with recent guidance in August, talking about changes to ownership and letting us know that the TPI portal that would be used to process changes, that's just not ready yet. And so in the interim, if you want to move forward with a change, that would be the type of change that would just require notice to the office, next slide, or approval from the office, then you can move forward with those changes. And you're doing it at your own risk, right? So you still have to comply with all of the regulations that restrict crossing the tiers and having more than a certain type of license. But you could go forward with those two types of license, those two types of changes. And regardless of the rule that requires you to get to provide the notification or the office's approval first, right? There won't be any adverse action taken solely for not having complied with that item. You will have to, next slide, provide information to the office, though, obviously, once the PI system change portal is up and running. We heard at the last Cannabis Control Board meeting that that's likely to be up and running at the end of the first quarter, so keep your eyes peeled on that. So that leaves the third type of change, right? And that's the type that requires board approval. And what are those? Again, the type that we're changing the composition of a license. What does that mean? That's essentially, according to the guidance, transferring or changing majority of ownership, right? So shares or interests or control, the individuals that are involved. And so for those, you're not going forward with those based on the guidance. You can't have those be effectuated right now. Next slide.
It's critical, by the way, for people to understand.
So while you're keeping in mind, right, those types of changes and those provisions, if you're thinking about getting involved in a card license or a social, economic, and equity license, we know that there's certain ownership and control requirements, and those have right, those are in place for a certain amount of time, and so you've got to be thinking about the changes, what kind of changes can be effectuated and when for those types of licenses. So with the statutory, regulatory, now the guidance in place, and we've talked about that background for when you need to make disclosures and the effectiveness of your involvement in a licensee, I'm going to turn it over to Mark to talk about some of the business aspects you may want to think about when choosing the license that you may want to get.
Thanks, Patricia. So at the forefront, there's a lot of things to consider when taking on investors or investing into a licensee. But the overarching theme here is do your due diligence. If you don't do your due diligence up front, you're going to be talking to attorneys like myself and Patricia because you have a dispute resolution and maybe litigation, and it's going to cost you money on the back end anyways. So spend money up front, do due diligence. Next slide, please. So at a high level, we'll go over some general restrictions, limitations that you need to consider when looking at a license or looking at investors. If any person involved in a license, whether it's equity or TPI, you have to be over 21. You have to be a U.S. citizen or be a resident of a territory that has a treaty with the U.S. You cannot be on both sides of the supply chain. You either are on the wholesale side, which is your cultivators, distributors, processors, or you're on the retail side. You cannot be on both. If you are a liquor store owner, a lot of SLA licensees are getting involved. You cannot sell the cannabis products and liquor products out of the same premises. And then owners cannot have financial or controlling interests in which is more than 20% in a license for more than 3 retail locations. And at this time, the office is not issuing more than 1 license per majority owner. Next slide, please. So the other consideration here is, whether you want to invest or into a operational licensee or a non-operational licensee. There are about 200 dispensaries operating in New York right now. Out of the card pool that have been awarded licenses, there's about 260 that either do not have a storefront or non-operational, which is where there's significant opportunity. But as I stated before, there are restrictions with these licenses, and you need to be aware of them and do your due diligence. So first question is, do you want to invest in a license that is already established, has a storefront, is operational, is selling products? Or do you want to find one that is not operational, that a person who doesn't want it, has a provisional license, doesn't want it, wants to sell it, or has a license and doesn't have the capital to get it operational? So there's a variety of considerations there. With cards and SCE licensees, those individuals have to maintain majority interest. So what does that mean? It means that they have control of the licensee, that you're putting money into a license that potentially you're not making all the major decisions on. Those are things you need to consider. Next slide. And then, so if you do want to invest in a non-operational licensee, a provisional license that doesn't have a property selected, when looking at properties, you need to look at the municipality. There's restrictions based on population. If the municipality is under 20,000 people, there's a 2,000-foot buffer between dispensaries. If it's municipality is over 20,000 people, there's a 1,000-foot buffer between dispensaries. And then there's obviously general restrictions on property, which is you can't be within 200 feet of a place of worship, and you can't be within 500 feet of a school. If there is a property selected but non-operational, you want to make sure that it has proximity protection, which is a separate review from the license with OCM. Next slide. If you are going to take on an operational license, they have a storefront, they're selling product, there's a few considerations that you should look at. When does the license need to be renewed, especially with the card license? what's the compliance look like? Do they have security and safety standards, training manuals in place? Are they reporting their tax properly? Has there been any investigations or inspections by OCM? You want to look at those reports. Has there been a statement of findings issued since opening that license? If there has, you need to look at it because now it's on OCM's radar. And this could obviously impact the renewal of this license. From a financial perspective, what kind of products are these guys selling? What is the competitive landscape? Where's the closest dispensary? How are they differentiating themselves from other licensees? What's the product selection? And then, the final thing is the brand. As Joe alluded to, Matt Flynn has done a great job at branding himself. What's the brand strength? Are they known in the community? Do they have a good customer pool? Those are things that you should consider. Licensee. Next slide. All right. Thank you guys very much. And if you have questions, please reach out to us directly. Information will be in the comment slide. Thank you.
Thank you to Joe, Tom, Patricia, and Mark for sharing your expertise with us. We certainly appreciate it. For those of you in the audience watching, tomorrow you'll be getting a recap of the program by email with links to the presentation and the full content of everything that was shared in the webinar. And finally, thank you again to Park Strategies and the Wagner firm for their insight, expertise, and time today. And I can't let you all go without a plug for our daily newsletter. So be sure to follow us at cultivated.news, subscribe if you aren't already, and watch your inboxes for everything you need to know about the cannabis industry to start your day. Thank you all again for joining.